Some mornings in a courtroom arrive already carrying the weight of everything that is about to happen. The morning Madison Whitmore walked through those doors was one of those mornings. She was 24 years old, the daughter of one of Manhattan's most feared defense attorneys, and she entered my courtroom the way certain people enter every room in their lives, as though the space had been constructed around their presence, and everyone inside it existed to confirm that impression. She was 12 minutes late. She was chewing gum loud enough to be heard from 3 rows back. Wireless earphones were jammed in both ears. Her oversized designer sunglasses remained on her face, despite the fact that she was now indoors under fluorescent courtroom lighting. An $18,000 handbag swung from her wrist as she made her way to the defendant's table, and 2 friends had settled into the front row of the gallery with their phones already raised, recording everything for social media content she had apparently promised them all morning. She dropped into the defendant's chair the way someone drops into a poolside lounger. Across from her, sitting perfectly still in the plaintiff's chair, was Sarah Chen. Sarah was 31 years old, a pediatric nurse who worked overnight shifts in the cancer ward of a children's hospital in Queens. She had immigrated from Taiwan at 12, learned English watching television, worked 3 jobs through nursing school, and raised twin 6-year-old daughters named Lily and Grace, largely on her own after her husband David, a Marine Corps reservist and construction worker, was killed when scaffolding collapsed at a Manhattan job site. She came to court directly from a 14-hour overnight shift, wearing her nursing scrubs, holding a single beige folder containing every receipt, every threatening legal letter, and 3 photographs of her daughters. She had not slept in 22 hours. Her hands were shaking and she would not look at Madison. She did not need to. The contempt radiating from that side of the room was something she had already learned to endure. I waited. I watched Madison settle in, observed the gum, the earphones, the sunglasses, and made no expression. Then I asked her, with the patience of someone who had been disrespected in 1,000 different ways across 35 years on this bench, to please remove her sunglasses. She complied with a theatrical sigh. I asked her to remove her earphones. She rolled her eyes in a way the entire gallery could observe, plucked them out one at a time, and dropped them into her bag. Then she said, in a voice calibrated to carry to every camera in the room, "Fine, but make this quick. I have a lunch reservation at 1:30 and I will not be late." The sound that moved through the audience was audible. Sarah flinched as though she had been struck. Madison did not notice. Without waiting to be asked for a statement, she launched into what was clearly a rehearsed monologue. She told the court that Sarah's car had been essentially worthless, that the $800 her father's firm had offered was generous, that Sarah should be grateful for the opportunity to upgrade from a 12-year-old Honda to something that did not embarrass the neighborhood. Then she looked at Sarah and produced a mocking imitation of an Asian accent, her vowels stretched into cruelty, suggesting that some people were simply born to drive Bentleys and others were born to drive Hondas. Sarah's hands began to shake so severely that the folder rattled. Her eyes filled with tears she was working very hard not to release. "Miss Whitmore," I said, "in this courtroom we use names. Mrs. Chen has a name. Use it." Madison threw her head back and laughed. Then she leaned forward and delivered the 8 words that would fundamentally alter the remainder of her life. "Honey, my dad eats judges like you for breakfast. You should know your place before you embarrass yourself on national television." Then she turned her face toward the main courtroom camera and held a smirk for the lens, perfectly positioned, entirely deliberate, certain she had just said the line that would make her untouchable and famous and viral before dinner. What followed was 11 seconds of silence. I did not move. I did not blink. I did not speak. The court reporter's fingers stopped above her machine. The bailiff's hand drifted toward his belt. The air conditioning hummed, and it was suddenly the loudest sound in the room. Madison's smirk held for approximately 3 seconds. By the 5th, something behind her eyes began to shift. By the 8th, she was glancing sideways at her friends in the gallery, searching for reassurance that had stopped being available. By the 10th second, her lips had parted slightly, and somewhere in the most instinctive corner of her awareness, The first signal had begun to register that she had made an error she could not walk back from. What Madison did not know was that 3 weeks earlier, a paralegal inside her father's law firm, a 28-year-old woman who had spent 2 years unable to sleep under the moral weight of what she had been asked to cover up, had walked into a shipping office and sent a sealed envelope directly to my chambers. Inside that envelope was documentation of incidents Richard Whitmore had buried, including a 2022 hit and run that had left a 34-year-old delivery driver named Marcus Davis permanently paralyzed from the waist down. His wife had quit her job to become his full-time caregiver. His 9-year-old son helped lift him out of bed each morning before school. His family had been living on Medicaid for 3 years. Madison had been posting photographs on yachts with captions that read, "Rules are for poor people." The 11 seconds ended when I leaned forward slightly, folded my hands, and spoke in a voice barely above conversational. "Miss Whitmore, I am very glad you mentioned your father, because I would like to talk about him as well." I reached into the top drawer of my bench and placed a thick manila folder on the surface in front of me, with the slow, deliberate weight of something final. Madison's eyes locked onto that folder. The gum she had been chewing fell from her mouth onto her blazer. She did not notice. "Let us begin with your driving record," I said. "The one you just told this court under oath was spotless." I opened the folder and read aloud. "March 2019, driving under the influence on the West Side Highway. Charge dismissed. November 2020, driving under the influence after striking a parked vehicle. Charge dismissed. June 2021, reckless endangerment driving 94 miles per hour through a school zone. Charge dismissed. August 2021, second reckless endangerment charge following a road rage incident. Charge dismissed. February 2022, leaving the scene of an accident. Charge dismissed. April 2023, third driving under the influence charge. Charge dismissed. I removed my reading glasses and looked directly at her. "Tell me, Miss Whitmore, did you forget about those 6 incidents, or did you simply assume I would not find them?" Her mouth opened twice. No words emerged. I continued. "What I have in this folder is not only your expunged charges. My research team compiled a comprehensive record over the past 72 hours. Since January 2019, you have been personally connected to 47 separate incidents involving property damage, vehicular collisions, or physical assault. In every single one of those 47 cases, the victim received the exact same template letter from your father's firm, the same predatory settlement offer, the same threat to pursue aggressive legal remedies if they did not accept it. I read 3 names aloud. A 68-year-old grocery store cashier whose car you sideswiped offered $400. A 20-year-old college student whose bicycle you ran over, breaking his collarbone, offered $600. A pediatric nurse whose car you struck offered $700. I set the pages down. "You do not have a driving problem, Miss Whitmore. You have a humanity problem." Sarah was crying openly. The bailiff had moved half a step closer. Madison's hands were gripping the defendant's table so tightly her knuckles had gone white. Then I reached into the folder once more and produced the sealed envelope the paralegal had sent me. I held it up so the cameras could see it clearly. This arrived 3 weeks ago from someone inside your father's law firm. Someone who could no longer sleep. Someone who finally did the bravest thing she had ever done. I opened it and read, "Marcus Davis, 34 years old, father of 3 children aged 9, 6, and 18 months. On October 14th, 2022, you struck him with your father's vehicle while he was crossing an intersection on his bicycle. You were driving with a blood alcohol level of nearly 3 times the legal limit. He was thrown 42 feet. His spine was severed. He has been paralyzed from the waist down for 3 years and 7 months. Your father's representative arrived at the scene before the ambulance. $8,000 in cash changed hands with the responding officer. The emergency room toxicology report was misfiled. 4 months later, a man visited Marcus Davis in his rehabilitation facility and offered him $50,000 and a non-disclosure agreement that has prevented his family from speaking publicly ever since." My voice cracked slightly with the effort of keeping it controlled. "Marcus Davis's 9-year-old son helps lift him out of bed before school, and you have been posting photographs from yachts with the caption 'Rules are for poor people.'" Madison came apart. She dissolved into uncontrolled sobbing, mascara running down her face in long black streaks. "You cannot use that," she screamed. "That is privileged information. My father will destroy you. My father will." I did not allow her to finish. "Your father is not here." And privilege ends where felony obstruction of justice begins. This court is referring your case to the Manhattan District Attorney's Office for immediate criminal prosecution on charges including vehicular assault, leaving the scene of an accident, conspiracy to obstruct justice, and perjury because you lied to this court under oath about your driving record 12 minutes ago. I am awarding Mrs. Sarah Chen the maximum allowable damages of $10,000 plus full legal fees. This whistleblower file, your recorded testimony, and all supporting documentation are being forwarded to the FBI's Public Corruption Unit because the 2019 dismissal involved a sitting judge in Westchester County whose name appears on your father's hidden payment ledger. I am formally recommending that the New York State Bar Association open a full ethics investigation into your father, Richard Whitmore. Bailiff, take her into custody. Madison slid from her chair onto the courtroom floor. Her bag spilled across the carpet. Her sobbing turned into screaming. "Daddy! Someone call Daddy! Please!" Sarah Chen put her face in her hands and wept silently, not in triumph. In the particular exhaustion of relief after 8 months of being told that what happened to her did not matter enough to pursue. The clip was online before Madison had finished being processed at the detention complex. Within 72 hours, it had accumulated 187 million views across every major platform. It trended in 23 countries. 3 hashtags reached the top of global charts simultaneously. The one used most often, more than 23 million times in the first week alone, was a simple statement that said everything the room had already felt. "Daddy cannot save you now." Madison's Instagram account, the audience of 340,000 followers she had entered that courtroom hoping to grow, turned against her with the speed of something that had been waiting for a reason. Every post was buried under comment after comment. The account was deleted within 18 hours. The screenshots of every caption, every yacht photo, every smug expression had already been preserved and distributed to hundreds of millions of people. Her 2 friends in the gallery were publicly identified within 36 hours and fired from their Manhattan internships within 48. A retired schoolteacher in Arizona named Patricia Owens started a fundraiser for Sarah with the title "Justice for Sarah and Her Daughters." Within 6 days, it had raised $487,000 from 31,000 individual donors across all 50 states. Madison was indicted on 7 federal charges, including vehicular assault, obstruction of justice, conspiracy, perjury, witness intimidation, evidence tampering, and racketeering as a co-conspirator with her father's firm. She was eventually sentenced to 4 years in a New York state prison. Her trust fund was frozen pending restitution to all 47 victims. Her mother filed for divorce 11 days after the verdict and filed paperwork to revert to her maiden name within 30 days. Richard Whitmore's law firm, which had stood for 32 years and employed 147 attorneys, dissolved completely within 6 weeks. The federal investigation judge Judy triggered uncovered bribes paid to 2 sitting judges, 4 police officers, and 11 court clerks across 3 states. Richard Whitmore was indicted on 23 federal counts, including RICO violations, witness tampering, bribery of public officials, and conspiracy to obstruct justice across multiple jurisdictions. His Park Avenue penthouse was seized. The man who had spent 3 decades telling people he ate judges for breakfast was eating meals off a plastic tray in a federal holding facility. Sarah Chen used the fundraiser money to pay off every debt, purchase a reliable car, and put down a deposit on a small house in a safer neighborhood where Lily and Grace could walk to school. She returned to her overnight nursing shifts, declining every television offer, because, as she said, her patients still needed her. She quietly donated $50,000 to a legal defense fund for hit-and-run victims, with Marcus Davis's family listed as the first beneficiaries. The 2 families became close friends. The case became a study in judicial courage at Harvard Law School. 14 states introduced legislation tightening hit-and-run penalties in Sarah's name. The clip of Madison being led out in handcuffs has now been watched over 240 million times. But the moment that stays with people is not her collapse. It is Sarah Chen's face in the seconds after the verdict landed. The quiet dignity of a woman who had been told for 8 months that she did not matter, finally understanding that she did. Money buys lawyers. Lawyers buy delays. But none of it buys the truth indefinitely. Every Madison eventually walks into the wrong courtroom on the wrong day. And on that day, no last name is larger than what is written in the folder, sitting in the top drawer of the bench.